Welcome, everybody. This is a little bit awkward, but folks online can see me as I'm just going to do the welcome and quick overview. My name is Barb Van Hoy. I am the Policy Planning and Engagement Coordinator for the City of Colorado Springs Housing and Homelessness Response Department. And I am excited to welcome you to Renter Rights 101. This event is produced really in partnership with several different local organizations, especially Colorado Legal Services, Pikes Library District, the Justice Center, Colorado Housing Connects, the Colorado Economic Defense Project, the Area Agency on Aging, the Independence Center. Thank you, the Independence Center, for hosting us here in person tonight, and also Silver Key Senior Services. We are really grateful for all of these partners working together to make these events possible. Tonight, we are going to share resources provided by many of those agencies, what kind of help is available for people who need help, how to access it. And then our attorney, Clinton Albert with Colorado Legal Services, will provide an in-depth review, well, a very big overview of the area of law around landlord tenant. So that includes lease basics, reasonable accommodations, modifications, deposits, repairs, eviction, updates on the current Colorado legislation, because there have been a lot of changes recently. And I do want to remind folks that there's a lot of information, and we are recording this, and we are going to share the recording as well as the slides. And so there's a sign-up sheet for those of you who are in person in the back of the room. We'll be sharing it on the city's website for our department. We have a Renter Rights page, and you'll be able to see a link to the recording there, and also the slides. And we also share it in our newsletter, so lots of different ways to get it. And for those of you online with Teams, we do have a transcript set up, so you should be able to view the captions if that makes it easier for you to follow along. And what else on that? Well, with that, I want to invite, there's a few of our partners who can very quickly talk about what their organizations do and how they can, what kind of resources that they can provide, just very quickly. And then we will be sharing the websites and links and phone numbers also by email to help you directly link to those organizations. So Lisa, you want to come up first?
Sure.
Thank you.
Hello, everyone. My name is Elisa Rizzo. I'm here with Community Economic Defense Project. So what we do is we help support folks who are facing eviction. Through the eviction process, we also have some state rental assistance funds, and those are specific to folks who are facing eviction. If you want to find out more information, there are some flyers located in the back. It looks like this. This kind of goes over the program overview of all of the different programs that we offer. And then at the bottom, there is a phone number. That is the number to our call center called Care Center. And you can call at any point to learn more about what rental assistance eligibility looks like. There's also some flyers that are more specific to the Colorado Rental Assist or Emergency Rental Assistance Funds. And then also another flyer for the EDI Care Program, which is a resource again for folks facing eviction.
Thank you. Definitely. Thank you, Lisa.
Hi, everyone. My name is Deb Hamilton. I'm with Pikes Library District. I have some of my business cards in the back. So if you have follow-up questions or want to start researching the law, we do have a legal research collection at the downtown library at Penrose. So just grab a card and we can set a time to meet, and I'd be happy to help you. All right, thanks for being here.
Thanks, Deb. Who from Independence Center?
Yep, so I'm Aurora. I'm actually in the housing department here. Welcome to the Independence Center. We're happy to have you guys. We're actually a nonprofit organization that helps people with disabilities create independence by leveraging their own unique abilities. We're the home of civil rights for people with disabilities, and we're one of 9 centers for independent living in the state of Colorado. Our 5 core services are information and referral. We do peer support, advocacy, independent living skills, and transition services. Additional services that are offered here are housing, benefits assistance, home modifications, deaf and hard of hearing, outreach, healthcare at home, and veteran-directed care. Our mission is working with individuals, their families, and the community. We create independence so that all may thrive. Should you be interested in obtaining more information about the Independent Center, we also have flyers, brochures, and things of that nature. If you want to become a consumer, we're always welcoming everybody in the community. So thank you.
Thank you, Aurora. Thank you, Aurora. Do we have someone online from Colorado Housing Connects? If so, you can unmute yourself, and I think we should be able to hear you. I'm not seeing Lisa. If you see her. Okay. I do not. Okay, we will be sharing that information. And I think we don't have anyone from the Justice Center tonight either. But again, we'll share those other resources out as well. So with that, I will very gratefully introduce Clinton Albert, who has been a landlord tenant attorney with Colorado Legal Services since, when did you start?
2017.
2017. So
2018.
been through a lot of cases and also a lot of changes in the law, and we really appreciate Clinton going through all of this information for us. So take it away.
Good evening, folks. My name is Clinton Albert. I am an attorney with Colorado Legal Services. I am assuming everybody online can hear me okay. If that is an incorrect assumption, please sound off in the chat and somebody yell at me. All right. So just a few things to keep in mind. First of all, this is going to be a very in-depth presentation. We are covering kind of the lifespan of a tenancy from application to move out. All right. With that being said, if you have a question, I'm going to try to get to them at the end. Hold your questions. If you raise your hand up 10 minutes into this, you're going to be holding your hands up for an extra hour because I'm not going to take questions in the middle of this. Hold until the end. All right. This presentation is for informational purposes only. If you came out tonight, first of all, thank you for being here in person and online, folks. Don't know why I just turned back to the screen like you were all standing back there. But if you came with, I have this issue with my landlord and I'm going to get that answer. No, you are not. All right. Housing issues require a thoughtful analysis of both the facts and the law that may apply to your specific situation. Tonight is not that night. This is not that venue. But look, if you are a member of this community and you have that question, maybe the information will answer it tonight. Maybe it won't. But please apply for services with CLS. You can do so online at our website, over the phone, or in person during business hours. All right, so like I said, this is the lifespan of a tenancy, so let's go. All right, before we're moving into the new place, first little helpful hint. Everything goes in writing. Everything, any agreement, it's in writing. You are working, this is a business relationship. This is a contract, right? You are paying money. You are receiving a residence in return for paying that money. Put it in writing. You can't have an oral lease. It's going to be tricky. What if there's a dispute over the terms of the oral lease? What written document do you have to resolve that dispute? None. So even if it is a oral lease, or if there is some kind of verbal agreement made, follow up. Send a text message. Hey, just to summarize our conversation from, I don't know what's today, March 11th, March 12th, March 13th, whatever it may be. My understanding is X, Y, and Z. Please confirm. If there's no confirmation, well, at least you have something in writing that you were basing that off of.
Can you use your camera?
Yes, I can. Oh, I'm sorry about that, folks. All right. There we go. Camera's up. All right. So when we're applying for a residence, that's going to be subject to the Rental Application Fairness Act. This is the statutes that govern what can be asked in an application itself, how can it be asked, and restrictions on that. So just generally speaking, application fees are not able to be charged unless it actually is used. All right. You can't charge different, landlords are not able to charge different amounts to different applicants. They must provide a written disclosure for the fee and then make a good faith effort to return any leftover remaining amounts. How can you get this? What is this application fee? Where is this derived from? It's either the actual cost of processing the application, or if you're processing a batch of them at one time, the average cost there. All right, there are the minimum maximum income that can be required is 200%. If you're filling out an application that says you must have 300% income, you don't. Keep filling it out. That rejection letter, the Attorney General's office can investigate violations of the Rental Application Fairness Act. So that may be an issue to report to the Attorney General. So, like I said, the maximum that can be required for qualifying for a residence is 200%. That 200% is not the total rent amount. It is the tenant's portion of the base rent, right? What does that mean? That means if there's a voucher, the voucher gets calculated into this. If the tenant's portion is $100 and their monthly income is $500, that's fine. Even if the property's rent is $1,200, but there's an $1,100 voucher. If the numbers are getting all jumbled up, that's okay. All right. The main takeaway here is you cannot be demanded to have more than 200% of the income, and you cannot demand on the other side of that that your possible tenants have more than 200% of income of the rent. Exceptions here are if this is an income restricted property, those questions can be asked in compliance with federal law to ensure that the landlord does not jeopardize the subsidy. Cannot consider credit score, adverse credit event, or lack of a score unless required by federal law. Credit history, you can't consider anything older than 7 years. Criminal history, no arrest records. I don't care if there are 1,000 arrests. If there are 1,000 arrests, that's zero reason to deny an application. No convictions that are older than 5 years old. Exceptions here, methamphetamine related offenses, generally speaking, simple possession wouldn't be one of those, but just meth generally. Offenses which required a person to register as a sex offender pursuant to Colorado revised statute, homicide related offenses, and stalking. What happens if a landlord doesn't follow the law? You send a demand letter. If you don't have the issue fixed in response to that demand letter, you can file a lawsuit. Here are the possible penalties for a lawsuit. Some of them, it can get up to $2,500 if certain violations are not fixed. What are those violations? We're not going to talk about them tonight. If you find yourself at this stage, a lot of things have gone wrong. Seek legal advice. All right. Another big part of rental application, applying for a residence is, let's face it, it's the application fees. Those can add up very quickly if we're going out and we're applying for multiple places. So enter our friend, the Portable Tenant Screening Report. This is a consumer report. The purpose of this is if you get one of these, you can take that one and give it to every property. All right. If you provide this to a property, you cannot be charged an application fee because that's what this does. This gives the background information. What does this report include? Name, contact information, verification of employment and income, last known address. Also, there's going to be a rental credit and criminal conviction history for each jurisdiction indicated in the report as a prior residence. Keep in mind, as this is a consumer report, if there are inaccuracies, you do have a right to challenge that by contacting the reporting agency. So landlords are required to accept this report. They may require additional things, such as that the report be generated within the prior 30 days, that they have direct access to the report, either through the website or either through the reporting agency's website or through a third-party website. It has to be made accessible to the landlord at no cost because the intent here is to lower the cost of applying for residence. So that's going to go both ways. And they also may require a signed statement from you as an applicant saying, hey, nothing in this report has materially changed since it was generated. All right. No fees can be charged for using this screening report or accessing one. And also, if you're a landlord, you've got to let folks know, hey, you can do this. All right, you can provide me with a portable tenant screening report instead of paying an application fee. So that's got to be advertised. All right, and you can see here the rules for the advertisement: in a location and delivered in a manner likely to reach the intended audience, or likely to reach the applicants. Written advertisements, website for your homepage of the website, online. And I think the worst way to do it would be to verbally advise somebody and then follow up with the written advisement. Just do the written advisement. All right. What are the exemptions here? In the limited situation where if a landlord only accepts one application at a time and returns the full application fee in the event of a denial, that landlord for that property would not have to accept a portable tenant screening report. If a landlord obtains their own consumer report, it has to provide you with a copy of that. And it also must include an advisement of your right to dispute any inaccurate information. And then if an application is denied, this denial must be in writing, and good faith efforts must be made to provide that written notice of denial to the applicant within 20 calendar days of the decision to deny. All right, so we've applied. We've been accepted. The lease is put in front of us. It is 50 pages long, and there is fine print all over the place. Read every word. You are signing a legally binding contract. You know what's not a defense? It was long. There was a lot of information. Well, you signed it. So if you signed it, you better read what you signed. Because what are you signing? What's the length of this lease? What's the rollover provision? Does it end or does it have a certain end date? That really matters as far as how your tenancy can end at the end of this. What about potential fees here? What about upkeep and maintenance? What are my responsibilities as a tenant once I move in here? What if I have a problem? Where do I send those notices? Who do I need to contact? How do I need to contact them? What about rules? Are there quiet hours? What are my guest rules? Is this an exempt residential agreement? If you're signing one for an apartment, spoiler alert, it's not an exempt residential agreement. But again, if I have a habitability issue, where am I sending that notice? Who am I getting in contact with if my heat goes out in February? What appliances are coming with the property, and what do I have to prepare for on my own? So again, exempt residential agreement. This is it is what it says it is. It exempts an agreement from a 10-day demand. So this is going to be something that's disclosed in a lease agreement, that the 10-day notice, 10-day demand provisions do not apply to this tenancy, and you only have a right to 5 days. This is pretty limited. It only applies to single-family residences, so it's not going to be an apartment, and it only applies to landlords who own 5 or fewer single-family rental homes. All right. Some leases may have an option to purchase. This is a very critical part of the lease agreement. So again, I don't care how long it is. If you are agreeing that maybe you purchase this property in the future, read it all right? Because this is probably going to be a large financial commitment. There's probably going to be some kind of substantial down payment to purchase that option. To say, yes, I want to buy this property in the future. Know what that is. It may require that to happen within the first 3 months of your tenancy, maybe 12 months, maybe 2 years. And because I've talked to folks who said, well, it's a rent to own. And then when you go through the document, I say, okay, well, what did you send prior to this date? Well, nothing. Well, it's what's called exercising the option. And if you don't use it, you may lose it. So again, read everything. Consult with legal counsel if you're unsure, right? Because you want to if you're entering into this, you want to understand what equity or what ownership you're building in the property and what protections you may have for that ownership interest. All right. When we're reading through a lease, here are some things that cannot be included, and if they are, the courts aren't going to enforce them. You cannot waive your right to the return of a security deposit. You cannot waive your right to the warranty of habitability. There is an exception. We will talk about it when we get to that part of the presentation. You cannot waive your right to the covenant of quiet enjoyment. What is this? This is essentially the promise that you get to live in your residential place like a residence. All right, that they're not going to run a printing press above it. I think that's the weird case law from the 1800s in Denver on this subject. You can't waive your right to a 5 or a 10-day written demand for unpaid rent, or 30 days if it's a CARES Act property. You can't waive your right to a court process for an eviction. You cannot. Late fees can only be $50 or 5%, whichever is greater. They must be disclosed in the lease. You cannot waive those caps on late fees. You cannot have an unreasonable liquidated damages clause that assigns a cost stemming from an eviction notice or action. Any attorney fee provision that's not reciprocal is unenforceable. So what that means is if you go to court, the prevailing party gets attorney fees if the court rules them reasonable. But if it's only we get attorney fees if we take you to court, not enforceable. You're not getting attorney fees. Can't waive the right to a jury trial, except you can waive the right to a jury trial for possession of a dwelling unit. Currently in Colorado, there was a Supreme Court case last year. It quickly got reversed. So at this point, there's not a statutory right to a jury trial. Depending on where you live, you can request one, but you'll be paying a non-refundable jury deposit, and there is a strong likelihood you will just be setting that money on fire and not picking a jury at the end of the day. You cannot waive your ability to join a joint action, a class action, a collective action relating to the terms of your tenancy. You cannot waive the covenant of good faith and fair dealing. That means you're going to act in industry standards, right? Cannot waive your implied covenant of quiet enjoyment. You cannot include any fee for not providing a notice of non-renewal for the end of the lease. If your lease says you have to give us 60 days notice, or we're going to charge you a fee of $500, not enforceable. But you can be held responsible for a landlord's actual damages. All right, so if you just move out 3 days beforehand, if we kind of think about this and walk it out a few steps, that's going to probably delay the advertising and the showing process. So you could be held responsible for the amount of days that the property went unletted or unleased. You can't have any provision in a lease agreement which characterizes anything other than rent as rent. Rent is the amount that you pay on a monthly basis for a roof over your head. Anything else is not rent. Any attempt to categorize it as rent will not be upheld by a court. Any provision which requires the tenant to pay a fee for a service which the landlord is billed by a third party, except at least may charge a fee no greater than 2% of the actual cost or up to $10 per month. You cannot have any. A subsidy provider cannot pursue an eviction for non-payment of utilities. What is required in a lease? That Colorado revised statute prohibits income discrimination and requires landlords to accept any lawful and verifiable source of money. Here's the exception to that rule. Landlords with 5 or fewer single-family rental homes and no more than 5 total rental units, including any single-family rental homes. If there are 2 houses, but one of those is a 6-bedroom, which has 6 rooms for rent, 6 tenancies, guess what? This applies. So we've read our lease. We've finished the novel. What a journey we've all gone on. We've signed it. Get a copy of it, right? You have a right to a copy of your lease. Request a copy of your lease. That must be provided within 7 days of you signing the lease. You want to have this that way. You have a reference if there are any disputes during the tenancy as well. So we've signed the lease. We moved in. Just as like this really doesn't have a cleaner place to fit in, but now that we're in our place, what happens if my landlord changes? What happens if the building is sold? The landlord changes, but the ownership remains the same. So think property management companies switch. The new landlord must contact you and give you an updated contact information to include a new address or addresses for any kind of notices. If the new landlord doesn't do this, you don't know why they wouldn't. They just oversight. Contact them. Ask them for the contact information, right? But in this situation, your tenancy is not going to be jeopardized, all right? This is just management changing over. Your lease is going to continue on. However, if your building is for sale and your tenancy is jeopardized, you'll see this more or we find this more common with homes, single-family rental homes where we're selling the property, we're getting out of rental. If you're concerned that your tenancy may be jeopardized, maybe not as necessary anymore given the 4 cause requirements that we'll get to. The one option you can do is you can take your written lease agreement, you can go to the clerk and recorder's office, and you can file your lease. All right, you can record your lease with the clerk and recorder. If you do that, that puts any buyers on notice that you have a possessory interest in the property, and they would have to respect your lease. So if you don't have any current lease agreement, then you may want to talk to the new owner, propose a new rental agreement, because at that point it's going to be trickier. However, this really doesn't come up as often anymore, I would say, given the changes to the law for cause-based evictions requiring 90-day notices if a home is to be sold. All right. What about rent increases? One time in a 12-month period. 60 days written notice. If you have a written lease agreement, let's say a 12-month lease agreement, can't change your rent in the middle of it. And also, landlords are not able to terminate your tenancy for the purpose of getting around this. Again, that's going to be lesser now with the for cause, but still, can't give a 21-day notice to quit and say, well, here's your notice to quit, or you can pay the new renting. You can pay this new rent amount. Late fees. All right. So, when you're looking through your lease, you're reading through it, be mindful of this, okay? Or if you're writing a lease agreement, be mindful of this, okay? You can't charge a late fee unless the rent is 7 calendar days late. The late fee can't exceed $50 or 5% of the rent, whichever is greater. And the late fee must be disclosed in the rental agreement. I would argue that if your rental agreement just says $50 or 5%, whichever is greater, it's not actually telling you what the late fee would be. So that would be an argument that's vague. You can't be kicked out. You can't be evicted for the non-payment of late fees. You can't terminate a tenancy for the non-payment of late fees. You can't impose a late fee on a subsidy that's late. So if you're on a housing voucher, you cannot be charged a late fee because the voucher was late.
What if you've got a voucher, they pay their portion there on time, but you pay yours, say three days after the due date, and you get a late fee?
Is 3 7?
Yeah,
3 is 7.
3 is not 7.
Okay, 3 is not 7. Think about that. You just said I didn't pay 3. I pay my rent 3 days late, and then you told me that 3 days is not 7 days. Okay, so again, questions at the end. All right.
Okay. Sorry.
That's okay. So you're going to see why, because we're on slide, I don't know, maybe 20 of 160.
Oh.
Okay, we're going through it all tonight, folks. We're going to try to. All right, so you can't charge a late fee more than once unless the totals of late fees 1, 2, 3, 4, however many it be, stay within that limitations. All right, no interest on a late fee. And also you have to give written notice of a late fee within 180 days of the rent being late in order to charge it. It's a defense against an eviction that the late fee statute has been violated. Late fees are distinct from rent. If rent is applied to pay late fees, that is a violation of the late fee statute. So what does that mean? Well, first of all, if you're reading through your lease and you say, well, that doesn't look right to me. Well, guess what? You can't be charged late fees. It's void and unenforceable. So if you're writing a lease agreement and you write in a late fee provision, which isn't compliant with what we just talked about, it's not going to be enforceable and your late fees are going to be 0. All right. It doesn't matter if you do your ledger the right way. If your ledger is in compliance with the law, it doesn't matter because the lease has to be in compliance with the law. All right. If as a tenant, if your landlord violates this, you give them a demand letter. The violation alone entitles you to a $50 penalty. In that demand letter, you provide 7 days to cure. At the end of that 7-day period, if that's not fixed, you can file a lawsuit. What happens at the lawsuit? Here are possible penalties there. It can be a penalty of up to $1,000 for each violation payable to the tenant or the homeowner. That's per. So if you charge a late fee of your rent is $1,000 a month and it's late, and on day 3, your landlord charges you a late fee of $200 a month, you pay the $1,000, you don't pay the $200, and then your landlord takes you to court for the remaining $200. Let's count up the ways we have gone wrong. Late fee charged less than 7 days, 1. Late fee greater than $50 or 5%, 2. Taken to court for the eviction, that's late fees. If there's a demand letter there, that's 3 violations on the same. That could be $3,000. All right, so this can become problematic. All right, we're about to move in. The truck's outside. Our friends are waiting. We've conned them all into coming to help us move. Before that first box touches the floor, take camera, take your phone, whatever you're going to use, go through and take an obscene amount of photos. Obnoxious. I want you to have to use all the data on your phone to have all these pictures. Why? Because you're going to go through each room. You're going to take pictures of the paint. You're going to take pictures of the cabinets open. You're going to take pictures and make sure that the water pressure is good on all the appliances, that the refrigerator is open. You're going to take pictures of everything. You're going to lift up your stovetop and you're going to take pictures under there. All right? Why are you going to do this? Because you're documenting what things look like. All right? You're doing the legwork on the front end of your tenancy in the event there's a security deposit dispute on the back end. Also, if you're a landlord, do the same thing. All right, you're going to have a date. You're going to have a date and timestamp from the metadata on the picture. It's going to tell you when it was taken. All right, so you're going to have that clean copy of information. And again, if it's damaged, take pictures of it. If it's undamaged, take pictures of it, because this is what you're going to rely on in a security deposit dispute. Also, send them to your landlord. Send them to you. And if you're a landlord and you took pictures, send them to the tenant. Keep the communications open. All right. Good communication makes for good relationships. All right. What about a walkthrough? Now that we're moving in, there's no right to a walkthrough. You don't have to do it. But I think this is best practice. And why is this best practice? Because you have a chance to talk. You have a chance to go through and flip light switches. All right. You can make little notes on, hey, these light bulbs need to be replaced. Hey, that leaky faucet needs to be fixed. That door needs a squirt of WD-40 or something on it. All right. You're entering into this contract, into this lease agreement with the same understanding. All right, and on the same page. Be critical here, but don't be unreasonable. All right. You're not being a bother by pointing out any issues. Remember, like I yelled at the beginning of this, you are paying money. This is a business. All right. Your landlord's in the business of renting properties. You entered into that business agreement with them so you could live there. All right, now we're in the home. Great, things are going wrong now. All right, so the warranty of habitability, this is the promise that your resident is fit to live in as a human. All right, there are a list of things that must be present by law. There are a list of things that must not be present by law. And if they are, your home is presumed to be uninhabitable. So, what are the conditions subject to the warranty of habitability? All right. Just bear with me. All right. We've got to have sufficient waterproofing, weather protections, doors, roof, windows. All right. The plumbing and the gas has to be in good working order. There used to be photos on that slide. I don't know where they went. Running water, reasonable amounts of hot water, proper fixtures and connections to sewage disposal systems. Oh, looks like I've lost a few photos here. Sorry about that, folks. Don't know what happened to them. Heating facilities must be functioning in good working order. They also have to be in compliance with the law. All right. So if you have an issue or if code enforcement has come out and red tagged a heater or a furnace, that's probably going to double as a warranty of habitability issue. Really sorry that I'm, again, losing photos. Wiring, electrical, that's all got to be in good working order. Common areas under control of your landlord must be kept reasonably clean. There also must be an appropriate extermination in response to infestation. I am very confused now as to why none of the photos are showing up. But oh, okay. Well, sorry about that. If you can just imagine, there were bed bugs and mice and something else. It was really gross looking. All right.
Thank you.
Just to paint the visual picture for everybody here. All right. So, as I said, this is in depth. We've got another 100 plus slides to go. If you've registered, you'll get the slides. If you haven't registered, you'll get the slides.
Or there's a sign-up sheet in the back.
Yep. Sign up sheet in the back. If you're online, go back to how.
I'll put the link in.
Thank you. The link will go in the chat. So if you're online, go in there, register. All right. Just because I know I'm speaking quickly this evening, this is a very dense slide. We're not going through it. This is the process and the procedure for how to handle bed bugs. All right. If you are a tenant and you suspect that you have bed bugs, you have a duty to tell your landlord, hey, I think I have bed bugs. Put it in writing. All right. Generally speaking, when we are talking about the warranty of habitability, yes, your landlords have to provide you with a habitable place. But as a tenant, you have to let them know that there are problems. How are they going to fix something if they don't know it exists or that it doesn't exist? All right. Also, with bed bugs, landlords are responsible for the cost of treatment. Right. An infestation of bed bugs also creates a rebuttable presumption that your home is in a condition which materially interferes with your life, health, or safety. Also request an alternate residence. We'll get to that a little bit later. But bed bug infestation, notice of the bed bugs, request for a hotel room. Your landlord is responsible for the cost of treatment. You are responsible to get your place ready to be treated. If you have to pull furniture away from walls, got to do it. You've got to flip that said furniture over and rip up any upholstery on the bottom. Got to do it. You've got to bag clothes, bag them. All right, because if you delay the treatment, that's when you could be on the hook for that cost. Here's more of the process procedure. All right, this is why we're not going through everything, but here's liability. So landlords who fail to comply with the process on the prior few slides are going to be responsible for a tenant's actual damages. But if you're refusing to let your landlord fix it, or landlords, if you've got a tenant that refuses to let exterminators in, all right? We all want this problem to be fixed. You can take them to court for injunctive relief and have the court order them to order your tenant to provide access, which could be granting access to the dwelling, making sure they cooperate with the inspection and treatment, and also assessing costs. It could be if that infestation spreads and folks, it's bed bugs, it's gonna, all right, that can be really expensive. So if you have the problem, get it fixed. Cooperate with the process to get it fixed. There has to be an adequate amount of outside receptacles for garbage. If we're talking, I think a single trash can would be insufficient for any number of the new apartment buildings being built downtown, which is why they all build dumpsters. Working floors, stairways, and railings. Again, there were pictures here. If you can just imagine really decrepit stairs and railings broken off, those are also issues that can be addressed. This is a small one. Locks on exterior doors, security devices on windows that open. Maybe not so much the locks on the doors. That's kind of pretty common sense of, yeah, I don't really have a secure, it's not safe if anybody can just walk in, jiggle the handle, and come on in here. But if you've got a window that opens, it has to have a lock on it too. There also has to be compliance with all housing, building, applicable housing, building, and health codes, which materially interfere your life and safety. Mold has its own definition. Here is the definition for mold. I'm not getting into it. Request the slides. Go register. There's a timeline for response for mold. We're going to get to that in a little bit. I'm not reading the definition of it. Here are appliances. Appliances are a little bit different as well. They also kind of include portable, kind of includes air conditioning now, kind of not. But generally speaking, it only applies to refrigerator, range stove, or oven. If we think about those three things right there, that's what gives you a kitchen. And that kitchen is what turns a hotel room or something, or a short stay, into a long-term residence. All right. And also, if something is written into the lease agreement, then the warranty of habitability covers it. So, if you're a landlord, be mindful of that. Also, that's why we're reading our leases, every single word of that little packet that we're getting. Okay. Also, if you make a demand based on an appliance, the example that I always use is if you have a fancy smart fridge that tells you the weather and wishes you good morning, and that breaks, and you get a normal fridge like I have, which just keeps your food cold, that's fine. Okay. You don't have to get the talking fridge again. Any condition which materially interferes with life, health, or safety. This can be subjective based on, your individual characteristics and what you have going on. But also the legislature in the last year added a handy dandy list for us. All right. Who's ready for another list? Hopefully all the pictures on this work. So if a certain condition exists in the property, the law is going to presume that the place is uninhabitable. They're going to presume that it materially interferes with your life, health, or safety. What are those conditions? Oh, lack of waterproofing, weather protect. If you've got a hole that lets the weather in, that's a problem. As an anecdote, I worked with somebody once who had a pallet nailed over the door frame where a front door was supposed to be. That was the door. It didn't open. All right, that's a problem. Judges aren't going to like that. Any hazardous condition of gas piping, gas facilities, gas appliances, or other gas equipment. Yes, if your place is about to blow up like a firework on the 4th of July, that's a problem. Let your landlord know and request an alternate accommodation. Inadequate running water or inadequate running hot water. The exception here is when we have it listed underneath it, temporary disruptions due to necessary maintenance, repair, or construction, or temporary disruptions that a landlord could not have reasonably prevented. Lack of functioning heat facilities and equipment. Sorry. To shorten this up, if you don't have heat between October and April of each year, yeah, that's a problem. We live in Colorado. We get snow here. It gets real cold. So if there's no heat during that time, the law is going to presume that the residence is in a material condition which interferes with your life, health, or safety. Now, if you're sitting here thinking, well, today is March and it was 60 degrees outside. That's the rebuttable part of this. So as a landlord, you can show that this wasn't in a condition which materially interferes with life, health, or safety by rebutting that presumption with clear and convincing evidence. We'll get to that in a little bit. Any hazardous condition of electrical wiring, facilities, appliances, or equipment. Lack of electricity or disruptions that are caused by the failure to maintain said electrical equipment. Oh, look, I got a picture of ants. So again, rodents, vermin, pests, insects, that's also going to do that. Inaccessible fire exits or egress in accordance with applicable building, housing, fire, and health codes. So that's going to be a problem. Misaligned chimneys, fuel-fired heating, ventilation, cooling systems. You think about that, it's not working correctly. God forbid you have carbon monoxide being dumped into your house when you're trying to stay warm, you go to bed and you don't wake up. That's what we don't want to happen. Inoperable elevators. When the tenant has a disability that prevents the tenant from being able to use any kind of stairs. I saw a thumbs up there. I might have a guess as to what building you're thumbs upping that on. There are no other operable elevators that would provide you access to get out of your building. Think about that. You are now trapped. If there is a fire, how are you going to get out? All right, so that's why this is important. But keep in mind, this isn't just elevator. It's elevator, tenant has a disability, and has no other way to get the heck out of there in the case of an emergency. Like I said, these are rebuttable presumptions. Just because it exists does not mean that it is actually a condition which materially interferes with your life, health, or safety. I'm going to go back to the heat example because, gosh, it was just so nice out today. No court's going to, I don't find it reasonable to say, well, I didn't have heat on a 60-degree day, so that really materially interfered with my life, health, or safety. I don't think that today would be the day for that, even though we are within that rebuttable presumption time period. So, when does a breach actually happen? We've talked about all these conditions, but when does it happen? It doesn't just happen because your heat went out. It happens when your heat goes out and you've given your landlord a reasonably complete notice of the condition, and your landlord has failed to commence remedial action within the required time. Remedial action, they haven't fixed the problem. All right? They haven't made it right. You still are without heat. So, when does the fixing have to start? 3 different timelines to think about here. Material interference, 24 hours, right? Because if we think about it, that makes sense. This is a serious problem, which is really messing with your life, health, or safety. All right? You're requesting to be put up in a hotel room, so this is a problem where if it doesn't get better, it may very well get worse. Condition that is uninhabitable by statute. So outside of those life, health, or safety issues, let's say there's not a lock on a window that opens. All right, 96 hours to start putting a lock on. Mold. Here's the mold response that's required. And this we actually will go through. I don't want to go through the definition, but this we will. So within 96 hours of getting that reasonably complete notice, your landlord has to install a containment stopping active sources of water to the mold. has to install a high efficiency particulate or air filtration device to reduce exposure. There's got to be a filter put in there. They have to maintain this containment the entire time until the following things are done, which is establish protections for workers and occupants, eliminate or limit all moisture sources and dry them out, decontaminate or move any damaged materials as appropriate, evaluate whether the premises has been fixed, run another mold test, and then put everything back together in a way that tries to reduce the recurrence of mold in the future. So you send a demand to your landlord, a notice, or now, folks, a work order. If you have ever heard me in prior years screaming a work order is not habitability notice, you will not hear that tonight because it is. Yes, required to have a response within 24 hours of providing the notice of uninhabitable conditions. Well, what's this response got to have in it? Also, it can be 72 hours if we're talking about a natural disaster, or if the property is inaccessible because of damage due to an environmental public health event. What are we thinking there? Fires, flooding, mudslides. I can't get there. The river surged 4 feet and it knocked out the road. So in that response has to have the intention for fixing the problem, when that's going to start, when that's going to finish. File an insurance claim, great. You haven't done anything. All right, what about an alternate residence? Yes. If the residence is a condition which materially interferes with life, health, or safety, and you make a request. It is not automatic, you've got to make a request. Then the landlord shall provide a comparable dwelling unit or a hotel room as selected by the landlord at no expense or cost to the tenant. Landlords aren't responsible for any other costs that arise after the relocation period, unless the hotel is a certain distance away and they're providing a per diem, which hopefully we'll get to. That's a new law. I don't have that memorized. It's a per diem based on state employee rates. Tenants are responsible for rent during this time. And again, this alternate accommodation only applies to material conditions which materially interfere with life, health, or safety. So what can a tenant do if the landlord breaches the warranty of habitability? And again, I want to go back a little bit. There is no breach if you don't put anybody on notice. All right? Providing proper notice, not receiving a response. You can terminate the lease. You can obtain a temporary restraining order and or injunctive relief in the county court or district court. You're hearing temporary restraining order. Don't think of it as in the way we're all kind of wired to think about that. A restraining order is meant to prevent somebody from breaking the law, right? Or harming someone. In this situation, the harm is that you don't have a safe place. So it's to stop, it's to say, hey, you're restrained from having them live in an unsafe environment. You've got to go fix it and get in compliance with the law here. You can also defend against an eviction for non-payment of rent or a collections action. You can also defend against it if it is retaliatory as well. There are other monetary options such as withholding rent. If you're going to choose to do this, I'd check with some. I would run it past legal counsel first, because if you do it wrong, it could be an issue. And also keep in mind that you can bring a claim for a breach of the warranty of habitability outside of an eviction. You don't have to say, well, if I don't have heat, you just go ahead and file those eviction papers and I'll see you in court. You don't have to do that. You don't have to put the eviction on the table as well. You can just sue for a breach of the warranty of habitability on its own. You can also deduct the cost of repairs. This is an incredibly specific process. It doesn't apply to everyone. It doesn't apply to all issues. You have to get an estimate from a certified professional who you're not related to, and then your landlord can get their own estimate, and you have battling estimates. If you wrongfully deduct rent, then there's a problem there. It's a bad faith deduction. You automatically get evicted. So before going through this process, which is detailed and complex, talk to somebody to make sure you're doing it right. Are there any exceptions here? Yeah. The exception is when there is a separate agreement entered into between you and your landlord, where it's separate from the lease. It's not a lease clause. It's not a lease addendum. It's a separate document. It's signed by both parties. laying out what the tenant is going to be responsible for, and it has to be supported by consideration. Also, as a tenant, you have to be able to do the work, right? I am not a carpenter by trade. Or, sorry, that's a poor example. I'm not an electrician by trade. I cannot enter an agreement with my landlord saying, like, don't worry about it. I'll get all the electrical work done in this property. That's not going to work. One, I don't know what I'm doing. So it'd be a terrible idea for me to sign it in the first place. Also, it takes that condition off the table for warranty of habitability purposes. It also has to be supported by consideration. What is consideration? Some kind of payment, whether that's a rent deduction or something to that effect. There has to be consideration. And again, yes, have to have the skills to do the work. Chances are this doesn't apply to you, but if you have questions on whether it does, contact an attorney. All right, so we're at a hearing on the warranty of habitability. At the end of it, if the court finds a breach, the court also has to determine the reduction of the property's rental value in its uninhabitable state to the date of trial. So there's going to be a reduction. Also, in an eviction case, the court shall deny possession to the landlord, deem the tenant the prevailing party. And then the tenant has to pay the rent that has accrued to the date of trial, taking the reduction of value into consideration. So there may be a case where and the uninhabitability must have happened within 60 days of the non-payment. So this is one where if there's 2 months where you didn't have heat and there's non-payment for 5 months, and you go to hearing and you've got the rent money, we're supposed to tell you how much you actually owe, and then you get 14 days to pay that. And so long as you do that, there's not going to be an issue. It's also breach of the warranty of habitability as a defense to a collection action for non-payment of rent as well. Also, courts may order, a judge or magistrate may order that repairs be made, and shall order, if that does happen, is going to order that monthly rent be at that reduced uninhabitable rate until the repairs are fixed. So that means the court's going to continue having jurisdiction over the case. Retaliation. All right. Landlords are not able to retaliate against a tenant for making a good faith complaint regarding the warranty of habitability to the landlord or to a governmental agency, or organizing or becoming a member of a tenants association or similar organization. What does retaliation include? Increasing rent, decreasing services, terminating a lease without your consent, except as permitted by law, bringing or threatening to bring an action for eviction. Also, taking action that intimidates, threatens, or discriminates or retaliates against the tenant. I always love when we use the word to try to define the word again. So retaliation means that taking action that retaliates. So thanks, legislature. Retaliation is a defense against an eviction. You don't need to prove it was the only thing. You need to prove that the decision to terminate the tenancy was a motivating, and that your protected activity, whether that be making a good faith complaint, was a motivating factor that influenced your landlord's decision to engage in retaliatory actions. It's tough to prove, but it exists. When dealing with warranty of habitability, here are just some other resources to keep in mind. Code enforcement, wanted to touch on this very briefly. Code enforcement enforces city code. City code is not the warranty of habitability. For example, city code requires that there be screens on all windows. The warranty of habitability does not, and it requires locks on windows that open. The warranty of habitability addresses mold, and that the presence of mold can make your residence uninhabitable. City code doesn't say anything about mold, right? Yes, there's significant overlap, but again, it's to enforce city code. Warranty of habitability gets enforced in courts. However, contacting code enforcement is still likely a good idea, all right? In some cases, it's going to generate a written report that's going to be given to your landlord, and then your landlord is on notice of any uninhabitable conditions. All right. So, moving to cause required for residential evictions. All right. And let me just double check something. Oh, no. Okay. Well, I'm now seeing that a slew of pictures aren't going to be available later on, but we'll cross that bridge when we come to it. All right. So previously, if you'd received like a notice of non-renewal, a notice to quit, those are now going to be called a notice to terminate tenancy. There are limited reasons that a landlord is able to terminate a tenancy under the new laws. However, this does not apply to everything. All right. So it does not apply to short-term rentals, employer-provided housing, mobile home tenants who own their home, tenants for less than 12 months, tenants not known to the landlord to be a residential tenant. This does not mean squatter. Squatter has its own rules, right? That's not what we're talking about here, okay? It could be somebody living in a commercial property. You're a small business owner and you're living in your office and you don't have heat, good heat through October to, the warranty of habitability wouldn't apply. But in this one, this doesn't apply because we're talking about a commercial lease, and you're not known, and your landlord, your commercial landlord, doesn't know that you're living in the office, or it's a person on, it's a family member or a friend who's on tough times, and they're crashing on the couch, and landlord doesn't know they're there. All right, so doesn't apply to them. Also doesn't apply to properties where the landlord lives on the property or the owner lives on the property and it's less than 4 dwelling units, or if the owner lives in an adjacent property to the residential property and there's still less than 4 dwelling units. So a little compare and contrast. The notice to quit didn't have any reason at all. It could be for any reason or no reason at all, unless we're talking about housing discrimination, but that would have to be a stated reason. So different notice periods would be kind of dependent upon the length of the tenancy for these. With the notice to terminate tenancy, the reason is required, and that reason must be included in the notice. It must be specified in the notice. 90 days of written notice are required. All right, so what are the recognized reasons to terminate a tenancy? Everybody have these memorized? Great, we're going to go through them all individually. Okay, so demolition or conversion of a residential premises. If it's being torn down or it's being converted from residential to commercial or otherwise, then, or converted to a short-term rental, you can terminate the tenancy. 90 days written notice, including a description and timeline of the demolition or conversion, and it has to be a demonstration of the proposed date when that project will commence. So you have to pull some kind of permit or some kind of plans. It just can't be, I'm gonna get around to it once you're out. No. You have to start doing it now, because that's where you're going to get the end of the tenancy date from. Is you have to show that, or an application for a permit or license, right? Tenants during that 90-day period, you get to remain in the home. And again, this is also not a workaround to try to terminate a lease early. Substantial repairs or renovation. So if a landlord plans to make substantial repairs or renovations, they can terminate the property, or terminate the tenancy with 90 days written notice. Has to have the date to vacate. This notice has to provide an expected completion date and general description of the repairs or renovations to be completed, and that it proceeds without unreasonable delay to begin the repairs after regaining possession of the property, right? So why does that matter? Because if the work's expected to last less than 6 months, landlords have to provide the tenant with the notice, including the essentially with a right of first refusal, saying, hey, we're doing this work. It's good. We're going to renovate the kitchen and we're going to convert the bathroom into an office, or convert an office into a bathroom. It's going to be finished in 4 months. And when we're done, we're going to rent it out at this rate. Would you like to rent it? As a tenant, you have 10 days to respond to that, yes or no. Okay. If you say yes, then once that repair is done, landlord calls you, say, great news, office is converted to a bathroom, you're good to move back in. You've got 30 days to move back in, right? Unless you agree on an extended timeline in writing. A landlord cannot use this reason if it is to either 1, comply with the warranty of habitability, or 2, in retaliation. So All right, another reason that a tenancy can be terminated is the landlord or a family member of the landlord is going to move into the property, right? Has to move into the property within 3 months of the tenant moving out. The landlord's got to provide 90 days notice to the tenant, and also that there's no substantially equivalent unit available for occupancy by the landlord or family member in the same building, and does not list the property for a long or short-term rental for at least 90 days after the vacate date. A couple exceptions here. Active duty military and spouses of active duty military, that notice period can be reduced to 45 days, or the 90-day period can be extended to accommodate repairs for an individual with a disability to assume occupancy of the property, whether that's the family member or not. Another reason to terminate a tenancy is if the property is going to be withdrawn from the rental market for the purpose of selling it. So, because if you're planning on withdrawing it from the rental market to move into it yourself, we just covered that. All right. So, plans to sell the property, then may terminate the tenancy. Again, common theme here: 90-day written notice, proper service of the notice, and then does not list the premises for long or short-term rental for at least 90 days after the tenant's move-out date. If you sign a 12-month lease, you're going to get the 12 months, right? Unless there's some other reason to terminate it early. But these are not reasons that a landlord may terminate a tenancy early. Landlords, if you signed a 2-year lease agreement, you signed a 2-year lease agreement. So rather than trying to maybe circumvent the laws, offer a contract buyout. Well, we're in a contract, you can buy folks out of them. All right. Tenant refuses to sign a new lease with reasonable terms. Again, 90 days written notice after the tenant's refusal to sign the new rental agreement and properly serves the 90-day notice. If you're asking what's an unreasonable term, say that's up to a judge. All right. Landlord shall not increase rent in a discriminatory, retaliatory, or unconscionable way to get around the new law and force a refusal to sign. If your rent goes from $1,000 a month to $5,000 a month, with no repair work, that's probably not great. And that probably would not be a reasonable new term. But I don't know that for certain. That's a fairly educated guess on my part. Another reason is a history of non-payment of rent. All right. And if you're thinking, oh, well, if they pay it on the 3rd of the month, they're late. Nope, they're not. So it's 90 days written notice, properly served. So what is late? More than 10 calendar days after the day it is due, and the landlord provides the tenant with proper service of a written notice. If a payment is then tendered and made during the cure period on that demand, it's not late. So, and it has to be more than 2 times. So it's late payments with no cure, proper demands, proper service. Not just you were late. So for example, if anybody's gone through a period where they have fallen on hard times and they've had to use rent assistance, right? In a rent assistance case, what often happens is you have an initial demand saying you missed payment on this month. Well, we're probably not in that month anymore. So if the demand was given in January and then an eviction case was filed in February and rent assistance doesn't come through until March 15th, think about that, right? We have 3 months of non-payment, but we have 1 notice. So that's not 3 months of being late. That's not 3 late payments. That's 1 for this purpose. And it is 1 because we have 1 proper notice. If we have 0 proper notices and we have 18 months of non-payment, guess what? We have 0 months of late payment for the purpose of this statute. Because again, there has to be a proper notice served. Here is the state form for written notice to terminate tenancy. If you want to find these forms, go to google.com and type in JDF forms Colorado. You'll eventually get there. So again, just broadly speaking, for all of these reasons, all of them, there has to include a statement of the legal and factual basis for the no-fault eviction or no-fault termination of tenancy. It also has to have a mediation advisement. Again, a specific description of the alleged no-fault grounds, and must be written in a language that the landlord knows or has reason to know is the primary language of the tenant. That's a defense. If your tenant only speaks Spanish and you have been speaking through interpreters or family member, and then you give them a demand or a notice in English, it's not valid. How are they supposed to read that? Can't waive or modify any part of these reasons in a written rental agreement. So your landlord says, well, we can terminate your tenancy if there is one late payment. No, that's not correct. It wouldn't be enforceable. So if the landlord proceeds with an eviction not recognized for any of these reasons, it's a defense. Also, if the tenant loses possession without a court order, moves out on a written notice outside of acceptable reasons, they may be able to pursue a claim for unlawful eviction. The penalties for unlawful eviction are actual damages plus $5,000 or 3 months rent, whichever is greater. So it can get pretty expensive to not follow the law. So kind of circling back to our theme of the lifespan of a tenancy, we're at the end of the tenancy now if we haven't figured it out, right? We've just gone through a lot of the notices on what happens when a tenancy is terminated. So we've stayed past it, or we've stayed past a demand, we've stayed past a notice. So now we're facing an eviction. The legal term for eviction is a judgment for possession. The type of case is going to be called forcible entry and detainer. What does that mean? It's old-timey, not really worth it. It's whatever was meant in the 1800s, so not really worth going into today. I don't have any intention of doing so. But unlawful detention is what a landlord must prove at the hearing, right? It means that you are holding on to the property and you are doing so unlawfully. And you're doing so unlawfully because you have breached the contract with your landlord, and your landlord has given you proper notice of the contract breach, and you haven't taken any action. So we're talking about lease violations. Those are basis for it other than non-payment, which is very common. Substantial violation, which is by law going to be endangering the person, substantially endangering the property, drug-related felonies, violent felonies, crimes that carry a possible incarceration of 180 days or more and have been declared to be a public nuisance. Public nuisance does not mean it is annoying. If you want to think of three kind of broader categories, brothels, betting parlors, and bong shops are public nuisance crimes. All right, so think of sin crimes or vices. Whoops. If it is a lease violation, it must be a material lease violation. All right. What does the law define as material? I'll let you know when they do. So one newish basis for eviction beyond non-payment, beyond material lease violation, beyond overstaying the end of the lease agreement or a substantial violation is disturbing others or causing a nuisance. So a quiet enjoyment. So what does that mean? It means that your behavior is going to interfere with the quiet enjoyment of the landlord who resides in an immediately adjacent property or other tenants or occupants of the same property. But for this to apply to a landlord, they have to either live on the property or immediately adjacent. If they're at the end of the block, that is not immediately adjacent. Immediately adjacent is the neighbor. So the tenant has negligently damaged the housing accommodation. A demand under this section must provide an opportunity to cure it. It must contain a specific description of the specific conduct that disturbed others or caused a nuisance. The exceptions here, as a tenant, if you're exercising your rights pursuant to any law or rule relating to the residence, then you're not interfering with quiet enjoyment or constituting a nuisance. For example, let's say you work second shift, right? You get home at 2 a.m. Once you get home at 2 a.m, you take a shower. That is not a nuisance for you to take a shower in the middle of the night or use the bathroom and flush a toilet, right? If you think this sounds crazy, I am not making these examples up. All right, another exception. If you are a victim of domestic violence, then the victim of domestic violence shall not be found to have disturbed quiet enjoyment or create a nuisance as a result of being a victim. That's a long-standing rule where victims can't be evicted for being a victim of domestic violence, unlawful sexual abuse, or stalking. So here we've got, again, another JDF form. These are, oh, fun fact. This is not a valid one. Why is it not valid? Because it does not contain a specific description. I suppose it does. But a demand must contain a specific description. That's why the prior form isn't valid anymore. If you look at a JDF form, on the bottom of it, it's going to have the date when it was printed. Make sure you have the most up-to-date one if you're going to use it. So all demands have to have the date and time when the premises shall be returned to the landlord. If it doesn't have a time, it's not valid. It doesn't have a specific date, it's not valid. So saying 10 days from the date of service is not a date, is not a time. The demand must be in a language that the landlord knows or has reason to know as the primary language of the tenant. So how do these demands get served? Served by a known tenant occupying the premises, or by leaving a copy with some person, a family member above the age of 15. If you give it to an 8-year-old, that's not going to work. It can be served either personally or by posting. Personally is when it's handed directly to you. Posting is when it's going to be taped to the door. For it to be served by posting, there must be at least one attempt at personal service on 2 separate days. So 2 separate days is also important there. Can't go at 8:30, knock, no one answers. Come back at 4:30, knock, post. No, that's the same day. That's not how this works. All right. We're doing on time. Good news, folks. I think I've talked fast enough that we're actually going to have some good time for questions, and we might even get through all the slides if we're lucky. So, security deposits. As of last year, security deposits cannot be greater than 2 months' rent. So, your deposit can be, when can it be kept? Okay, we've now moved out of the property. All right, so our tenancy is over, but we may still have some issues. One of those issues would be the security deposit. It can be kept for non-payment of rent, abandonment of the residence, non-payment of any utility work, repair work, or cleaning work that was contracted by you for the unit. So what's normal wear and tear? That's the usual deterioration which occurs when living in a residence. If you have carpet around the entryway or any high traffic area is going to have more wear and tear. If the carpet is 20 years old, it's not going to be worth anything. So what is not normal wear and tear? Careless or intentional destruction of property. If you punch holes in a wall, that's not normal. So that's not going to be the usual deterioration which occurs when living in a residence. So we're moving out now. We're at the end. We're going to clean the residence. Again, there were pictures here. So just imagine that I put some very nice pictures here. It all made sense and it looked very visually appealing. Do another walkthrough if you can, right? Now remember when you moved in, you took an obscene amount of photos. You're going to go through those photos and you're going to recreate every single one of them on the way out. Why? Now you have the beginning, now you have the end, right? So you have a timeline. That's going to be some of the best evidence for you. Well, folks, I apologize. This would have made a whole lot more sense if there were keys there. So you're going to return the keys to your landlord. Holding on to if you move out, but you don't return the keys, they probably didn't know you moved out. Right? So holding on to keys is a big factor in a court determining if you still have possession of the property. You also have to provide a forwarding address. Your landlord is only required, or now your former landlord is only required to send the security deposit or accounting statement to your last known mailing address. Well, let's think about that. If you don't provide them with an address, what's the last known mailing address they're going to have for you?
That place.
That's right. That place that we all know I just moved out of. So give them an address. It doesn't have to be where you're moving to. It has to be a mailing address, right? Someplace that you can reliably receive mail. How long is it going to take? By law, 30 days. Chances are your lease hasn't written in 60 days because it can, all right? So if you're on a verbal lease, guess what? That 60 days doesn't apply because you're not on a written lease. What happens if your landlord does not return your deposit? You're going to send a demand letter. Sorry, I need to delete that next one. It used to make sense to send things via certified mail. That way we would know when it would be received. However, I wouldn't recommend that anymore. I would just have general tracking on it. Certified mail requires a signature. If you're sending it to a PO box, no one's going to sign it. And if I'm wrong, please call me out on this. But in my experience, anytime somebody has sent certified mail to a PO box, we've gotten updates that attempting. 4 weeks later, the letter gets returned because there's no one there at the PO box to sign for it. So just general tracking is probably a better move on that front. Keep a copy of the letter. All right. Going back to putting as much in writing as possible throughout your tenancy. Also keep copies of as much as possible. And keep it in a safe place. That way it doesn't get lost in the shuffle of life. All right, landlord may only refund part of your deposit if there's any kind of restrictive endorsement that says this is a full accord and satisfaction of the security deposit and any and all disputes. You want to be careful before you sign things, because when we sign things and we don't read them or we don't know what we mean, we don't know what we signed. All right, so we could have signed away rights. Don't do that. Talk to somebody first. All right. You send out a demand, you don't get a response, you can initiate a small claims action or in county court. Small claims court is designed for pro se litigants with amounts that are less than $7,500. So as rents are increasing, yeah, I think now you can probably find a lot more places where you can get above $7,500 on a security deposit. Not the initial security deposit, but if a court finds, you can seek treble damages, which means 3 times the amount of the deposit that's wrongfully withheld. All right. So if your security deposit was $2,500, it's all kept, and none of that was supposed to be kept. You're at the jurisdictional limit. Your security deposit was $3,000, and you're suing for $9,000. You have to file in county court, or you can file in small claims court, but you're going to limit your recovery at $7,500 because that's the maximum in small claims court. Early lease termination. Things aren't working out. We're moving for another job. It's just not. It's not feasible. We're scraping by, and it's just not a good. It's not a good fit. When can we do this? Sometimes a lease will permit it by its plain terms. If there's a breach of the warranty of habitability and it's not fixed, you can terminate that on 10 to 30 days. Notice I trailed off at the end there because I can't remember if the 10 to 30 days was changed to 10 to 60 days. Again, seek legal counsel. Also, protections, the statutes providing protections for victims of domestic violence, domestic abuse, stalking, or unlawful sexual behavior. Those victims have the ability to provide written proof of that to their landlord, terminate the penalty, terminate their lease with no lease break fee. If they pay a month's rent within 90 days, that then regains security deposit rights. Military orders, act of God, fire, flood, so long as that act of God wasn't caused by you, such as you set the fire. Also, multiple breaches of warranty of the habitability. So if the same condition of the residence makes the home uninhabitable at least 2 times within a 6-month period, and we're not talking about an appliance, then it's going to be a 14-day notice to the landlord in writing. It's going to be necessary to terminate the lease. Forcible entry and detainer. This is the eviction in Colorado. Landlords have to use the court process. Cannot resort to self-help here. It lists reasons they can, and we've gone through those reasons throughout this process. Let me check where we're at here. All right. Mediation. Mediation applies here's the definition for mediation. It means it's before a case is filed. It's an informal dispute resolution for the parties to sit down with a neutral third party, the mediator, to see if they can come to an agreement. All right. Tenant is eligible for, not all of us are going to be eligible for mediation. You have to receive SSI, SSDI, or cash assistance through Colorado Works program. The most common one that we come across is TANF. However, there are other cash assistance through Colorado Works. And you tell your landlord in writing, I receive this assistance. That's it. And when you do that, you have set forth your right to mediation before an eviction can be filed. So landlords are required to participate in mediation unless they are a 501c3 nonprofit organization that offers opportunities for mediation to residential tenants prior to filing a residential eviction in court. Or landlord has 5 or fewer single-family rental homes and no more than 5 total rental units, including any single-family rental homes. So mediation process is going to begin prior to an eviction. It's going to happen in that demand or in that notice to terminate. Landlords are required to ask tenants if they receive the types of income we just went over. Verbal questions don't count. As a tenant, you've got to respond in writing. All right. If you're thinking, well, I got a demand last year, and I don't remember anything about mediation on that. It was there. It was in fine print on the second page, I assure you. So that's why we want to read everything top to bottom, front to back that we receive in this process. All right. So for tenants, mediation does not have any cost for tenants. All right. Scheduling of mediation, that's going to be conducted by a trained third-party neutral trained third party. And then ODR shall schedule mediation for the first available date, no later than 14 days after landlord's request for mediation. Here in El Paso County, we have a number of mediators that really work tirelessly to try to get folks scheduled in as quickly as possible. Also, the EDI CARES program here also has mediation available for landlords and tenants, and sometimes that's incredibly useful. Sometimes that's enough to salvage a relationship, to save a tenancy, and to really write the shit back on where both you and your landlord are going to be on the same page. It's hard to find a place. It's hard to move. It's expensive to find a place. It's expensive to move. So if we can kind of fix the problem by sitting down and talking it out, that has a tremendous value that we can't put in. Well, we probably could put it in dollars and cents, and that amount's going to be high, and it's an amount none of us are going to want to pay. Can mediation be waived? Nope. 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 All right. So there's no specific language or state form required for the notice there. Oh gosh, where am I at? Sorry, there are pictures here. So again, these are just general requirements for notice to terminate tenancy. This is a notice to quit. So if the for cause doesn't apply, then the old rules would apply, meaning, let's say it's a month-to-month property, you've been there for 4 months, your landlord only has to provide you with a 21-day notice prior to the end of the month. So if you receive, what happens if you get one of these? For non-payment, start working on a rent, start seeing if you can work on any kind of rent assistance, whether that's through the Colorado Emergency Rental Assistance Program that was rolled out last month, whether it's through Catholic Charities, or sometimes we'll have funding available for folks. United Way, 211. The funding source, Kingdom Builders, Mercy's Gate can assist with up to $300. You can see my eyes kind of trying to find other places and referrals in the back of my head. So they're constantly changing. So be vigilant. Some organization may not have assistance today, but they may have it tomorrow. Or let's say for example, for Sarah, Colorado Emergency Rental Assistance. One of the requirements for that is that you've not received any rental assistance within the past 24 months. If you received rent assistance last year, let's say there was a medical emergency or lost a job, and you've fallen behind again, well, you're not going to be able to receive that rent assistance. Contact your landlord, work out a payment plan. All right. And when I say work out a payment plan, I don't mean ask, can I have a payment plan? Put forth something. Right? Put forth, what would this be workable? I'm going to pay off an extra X amount a month till we get caught up. All right. Or an X percentage of the total past due until we get caught up. Other violations. I have a pet when I'm not supposed to. Somebody was living here when I wasn't supposed to. I have a noise violations, and I'm disputing that. If you have documentation that you can show that didn't happen, provide that. Or let's say something, hey, you haven't mowed the lawn, you need to. Well, first of all, go mow the lawn and take pictures and send them, showing that you've come into compliance, all right? If you do nothing, then chances are if you fix the problem, but you communicate nothing, they might not know. And then you might get an eviction filed against you, which is going to be incredibly stressful. So again, this kind of goes back to clear communication, all right? Clear communication is a foundation for a good relationship, all right? If it's a notice to quit for substantial violation, if there's any documentation showing that you did not commit the substantial violation, or the affirmative defense for a substantial violation, you had no way of knowing of the substantial violation or stopping it. And as soon as you found out about it, you called the cops. If you have documentation showing that, for example, let's say your troublemaker cousin comes over to visit you for dinner on Sunday night, and then decides to do what they do best. And they go and they punch your neighbor. Great. And when you find out, get out and you call the cops. My idiot cousin just punched my neighbor. Well, that's going to create a defense against that substantial violation. All right. And also stop inviting that cousin over for dinner. All right. A notice to quit for a repeat violation. So repeat violations are not just that it happened twice. Of course, that is what it is. But it is that there's been a material violation of the lease multiple times. All right. But that material violation also has to have a valid demand. Right? So there has to be an initial valid demand, which is properly served. And then the problem was fixed, whatever it may be, but it happens again in the future within 12 months. Why am I saying 12 months? Because after that 12-month period, chances are there's been a new lease signed, so that prior violation kind of gets washed away. Again, notice to quit, notice to terminate tenancy. Make sure it complies with your lease, make sure it complies with the law. Maybe there's a lease extension to be worked out, or prepare to move out. Demands have to have this statement. It's from the law. Just says if you receive this, you receive that. Oh gosh. All right. So the summons has to have a statement that if you receive any of the assistance, SSI, SSDI, or cash assistance through Colorado Works, that you may have a right to mediation. So after mediation, you're going to be served if if there wasn't an agreement reached at the mediation to resolve the conflict, then the next step is going to be, papers are going to be filed in court. So it's going to be a summons and complaint. I want you to just imagine that I put a summons right here. Print out of that too. Very sorry for this, folks. I was not aware this was going to happen. This is the first for me. So the summons, there's language that must appear in the summons. If you got to this part and you're confused on, hey, does it have all the required language? There's the statutory site for you. Service, personal service, service by posting. If it's service by posting, your landlord can only get a judgment for possession and they can't get a money judgment. It also has to, the pleadings, the summons and complaint, and all the documents also must be mailed within 1 business day of posting. Just imagine, I put something else over here too. So answer, it has to be your legal defenses, right? There are a lot of human defenses, which are going to tug on a judge's heartstring. It's going to make them feel incredibly empathetic for what you're going through. And the law is going to say, I don't care, kick them out. Because that's what the law says in these cases, right? If you don't put forth a legal defense, you're going to get evicted, right? So what are some very human defenses that are not legal defenses? I've been hospitalized for the last 2.5 weeks, and I've been out of work. My child's been sick. I was fired. I was illegally fired, and I'm going through an unemployment claim right now.
Somebody kicked us off the ride.
So a judge could be brought to tears by what you tell him. The law's not. Right? So it may seem silly to think that not having a time on a demand is going to avoid an eviction, but having a hospitalized child, which has caused me to miss work, will not avoid an eviction, seems inconsistent. If it does, That's the law, right? I can appreciate that. So, answer is due by 5 p.m. on the date of the return. Here in El Paso County, if you get a summons, it's going to say it's a non-appearance return. It's going to be super confusing. Because you're going to show up at the courthouse at 8:30 or 9 or 9:30, and you're going to say, where do I go? And they're going to say, you don't have to be here. Well, what do you mean? It says I have to be here. It's going to say, you are commanded or directed to appear at the El Paso County Combined Courts at 8:30 in division non-appearance. So you have to either file an answer or reach a settlement, and that has to be filed with the court by 5 p.m. If there is an improper notice, that defense must be raised in the answer itself. It cannot be raised for the first time at the hearing. Trial has to be set within 7 to 10 days after an answer is filed. So if you file an answer before a return date, because from the time of service, so when you get served with the summons and complaint, your return date is going to be 7 to 14 days after that. Your trial is going to be scheduled 7 to 10 days after you file an answer. Okay, yeah. Sorry. Between filing an answer and setting a trial, the court's going to order your landlord to provide all documents related to the current action. If you have raised the warranty of habitability as a defense, you must provide your evidence 96 hours before the hearing date. Your landlord must provide their evidence 96 hours before the hearing date. If they don't do that, then the court shall continue the case. All right? Or if they keep not doing it, then they could just exclude the evidence. Anytime up until a judge enters a judgment for possession, if we are talking about a non-payment, you as a tenant have a right to pay the amounts directly to the landlord, or if they refuse, go to the court and deposit it in the court registry. So if you're a landlord and your tenant is trying to give you full payment and you say, no, we're in court. Okay, they're going to deposit it into the registry. You're going to file a motion to have it released, and maybe a month later you'll get your money. So don't do that. Just take the money. Once the court confirms the full amount's been paid, they're going to vacate any judgments that may have been entered. They're also going to dismiss the case with prejudice. If you don't mediate, that's going to be affirmative defense. Even though I went through the whole spiel about appear, make sure that it's non-appearance, make sure that you do something. If you do nothing, you're going to get evicted. Writ of restitution, that's the legal document that allows the sheriff and law enforcement to come into the residence, remove you, remove your property, put your property outside, and have the property rekeyed and turned back over to your landlord. That can happen 10 or 30 days after a judgment. You're thinking, well, is mine going to be 10 or 30 days? It's 30 days for folks that receive SSI, SSDI, or cash assistance through Colorado Works. The basis for that is that in the legislative intent, they identified that the members of our community that do receive this assistance are the most vulnerable members of our community, and they have the highest barriers to housing. It is harder to move, it's harder to apply, it's harder to find a place that's going to accommodate their needs. Unlawful removal or exclusion, illegal eviction. All right, so if this has happened, court process has been filed, not just if you disagree with the judge's decision, then that's where the $5,000 or 3 times the monthly rent can come in. And you can also be ordered to get your place back if you were illegally evicted. Fair housing, this prohibits discrimination based on protected class. There are exceptions to it. Again, I'm going to speed through the rest here, folks, so I can actually get to some questions for the last 20 minutes or so. There's a prohibition on discrimination in income. We kind of covered that up front with the lease review, if you remember, 100+ slides ago, talking about what must be in your lease. And this must be in your lease is that there's a prohibition on income discrimination. Service animal versus emotional support animal. A service animal is protected by law under the Americans with Disabilities Act. It can only be a dog or a miniature horse. It must be trained to perform certain tasks. Emotional support animals are not covered by the Americans with Disabilities Act. An emotional support animal will be subject to a reasonable accommodation through fair housing, right? What's a reasonable accommodation, you may ask? So it's discrimination to refuse to make reasonable accommodations necessary to afford a person with a disability the equal opportunity to use and enjoy the residence. No magic language to make this request, but it must be in writing and it must state the actual accommodation you are requesting. Sample letter is, well, if you can imagine, here's the sample letter. Again, I'm sorry about that, folks. I'm going to go through and make sure that the slides that I sent to Barb to be emailed out to everybody actually have all these pictures in it. Mobile Home Park Act. Here's Mobile Home Park. If you have to have a written lease, demands a notice to quit for 90 days, security deposits no greater than 1 month rent, 72-hour notice to enter. Here are lease requirements. Here's 4 cause evictions in a mobile home park. Here's when a park can change its rules. If you say yes, immediately. If you say no, it's 60 days, and then the rule goes into effect anyway, so long as it's necessary. Here's your right to privacy. Mobile Home Dispute Resolution Act. We're definitely not going through this, but if you're a homeowner in a park, you can file a complaint with the Mobile Home Dispute Resolution, Mobile Home Park Oversight Program. Sorry, I had to think what the acronym stood for. MHPOP. It's a state program, so you can file a complaint there. Here are other provisions from the Mobile Home Park Act. I'm trying to get to questions. Before I get to questions, there was a significant chunk of the warranty of habitability we did not cover tonight. Not significant, but the chunk that we did not cover dealt with portable cooling devices and a little bit more of heat, extreme heat events, what landlords' duties are with respect to cooling shelters, the restraining order process as well. So if you're thinking, well, I want to learn about that, where's that information? It was last September. If you find the September 2024 renter rights presentation or the June one from 2024, you will hear me talk about all of that. It should be recorded. It should be available on the city's website. I think maybe if I just like squeal a little bit longer, that will become true. All right. All right. Thank you all for your patience, and thank you all for holding your questions till the end. All right. I'm going to go through the chat here.
Just two. The first one's at 6:14.
6:14?
In the chat.
Oh.
Just so you don't have to scroll.
Oh, thank you.
Yeah.
6:14, 6:22. The landlord refuses your rent payment due to non-payment of past late fees, saying that it would be considered a partial payment if past due late fees are not included with the current rent payment. What, if any, are the tenant's rights? Document your attempts to pay. Right? Your landlord cannot apply, landlords, you can't apply rent payments to late fees. I'm very sorry, that's what the legislature said. Not me, legislature. Okay, so if your tenant's trying to pay their rent, they have outstanding late fees, and you're saying that's a partial payment, you're violating the law, you're violating the late fee provision, you are opening yourself up to liability. If you're a tenant and this is happening to you, document it, keep it in writing, okay? If an eviction case is filed against you based in this type of actions, and they're still refusing it, one thing to consider would be, well, might be where you want to, talk to an attorney. Colorado Legal Services is at the courthouse Tuesdays and Thursday mornings between 8:30 and, for intake purposes, 10:45. Okay, so you can, if you have a return date, you can come see us there. If you have a question like that, if we have enough resources, we may be able to assist you that morning in getting an answer written. But if we think about it, you can't be evicted for the non-payment of late fees. Your landlord's refusing to accept your rent payment. They then file an eviction. You deposit your rent payment into the registry, same as giving it to your landlord. The landlord's then left with the only case being they haven't paid late fees, Judge. All right, so that would be a potential defense on that front. Thank you for that question, Carol. For disputing late fees, can you tell us a little more about what a demand letter should include? A demand letter should include what you are disputing, why you are disputing, how you want it resolved. You charged me a late fee on March 7th for non-payment of rent for the month of March. Here on March 5th, I paid my rent. Or on March 7th, I paid my rent. The late fee is charged less than 7 days after it is due. I am requesting that you refund this $50 and you show me proof that it's been knocked off my ledger or something to that degree. There's no magic form here, but make sure that you are clear in what the issue is why it is an issue, and what you are asking to be done to fix it. Folks, you've been so patient. Any questions?
I have a question.
Yes, ma'am.
This is kind of weird. My rent is billed by the apartment complex, but there's a third party involved. It's called RealPage. You probably know who that is. Anyway, I won a $250 contest, put it that way. And they deducted it from my rent. The apartment complex did. But RealPage has not. It's been on my rent for 4 months. It says balance forward, $250. And they keep telling me, oh, you don't need to worry about it.
Do you have it in writing from them?
Well, you mean the bill?
I mean, not worry about it.
Oh, no, I don't have that in writing from them.
You got nothing then.
Okay,
All right, get it in writing. Also, you're asking if it's way too specific of a question. Right?
okay, sorry.
That's okay. You don't have to apologize. I'm
This
just
is
going to
weird.
shoot them down. It's weird.
I don't know what to
But
do about
as a
it.
general thing, get the promise in writing that you don't have to worry about it. Then you have, and then once you get that, send it to them. All right, because then you have the dispute from them. Sir, I believe you had a question.
Yeah, I understand in living in a supportive living apartment, and the visitation rules are not what they should be. They're restricting my visitors, tell them what time and all that good stuff.
I don't know what your question is, sir, but the answer is going to be, I don't know. Yeah, I get to do that. It's so great.
Yeah, I kind of
But-
figured that, but
But one, it's too fact specific, but the main reason, that's the main reason I can't answer it tonight. But the more, even if I could, the answer is I don't know.
yeah, it's
Because
gonna be,
you
yeah.
described, I'm living in a supportive living environment, which is going to have its own rules, and it may even be subject to different rules. For example, sober living facilities are exempted from some eviction procedures for certain issues. All right, so when we're kind of in those unique housing situations, there may be unique rules, and I'm not flying off the hip here to give you advice. One, I'm not giving you advice. This is informational purposes only.
Right.
But Justice Center's Call Lawyer Clinic, Wednesdays, 7 to 8:30. Also, you can also apply for CLS assistance as well to have somebody take a look over what's going on and give you some advice. I'm going to go that way. Ma'am in the pink.
Is there a limit on if you get a notice, what was a verbal notice? Now I know I need to get it in writing.
Verbal notice ain't where the
They're
paper's written on.
saying that your rent's gonna go up in June,
That's cute.
$20
Bless their hearts.
Yeah,
That and 50 cents will get you a cup of coffee.
but the rent's gonna go up. So is there a
It's
limit
not.
on how much they can take your rent up?
There's no limit on how much, there's not a cap on how much the rent can be increased. Your rent's not going up in June on a verbal notice. Any rent increase must be in writing.
Okay,
So that's why I was being a little smart aleck on bless their
Okay.
hearts.
so don't say nothing, just go ahead and keep paying what I was paying? Because I didn't get it.
Not too much. Too much.
Okay, I'm
Too
asking.
much.
I'm asking.
That's okay. You can ask it. I'm going to say I can't answer that part. All right. So that's
But I
what
need to tell them these to be right.
I'm just saying that's not what I'm telling you to do either. I am saying that a rent increase, in order for it to be a valid rent increase, must be in writing and must provide 60 days of notice for the prior to the rent increase
Okay,
going
you're
into
talking
effect.
really low, I can't hardly hear.
Oh, I'm sorry. A rent increase must be in writing, and it must be 60 days prior to the rent increase going up. It also cannot raise the rent in the middle of a contract term. All right. If you have any other questions on should I do this or should I do that, I can't answer those.
I got it. I got what you're saying, but I have another question. That was one of them.
Okay.
The place where we're staying, one thing I did not do was take pictures when I moved in there, and that's a lesson I learned. We pretty much had to go in there and clean the place up before we moved in there. And so that's all water on the bridge now, I know, because I didn't take pictures. So the place looks really good, and we kept it up very nicely. And
Great.
that's why I think they're going up on rent, because it looks nicer. So, but anyway, yeah. But anyway, what was the question I was gonna ask? Ask someone else and I'll come back to you.
All right. We'll circle back. Yes, ma'am.
I have a neighbor that I'm.
Folks, you keep starting off with all the facts. I'm really sorry, but you keep asking me for advice. I'm going to start shooting them all down.
then we have quiet hours. They've repeatedly violated the quiet hours. I've documented this, date, time. Okay, repeated violations all over the place on that. What are my rights? I mean, I know this comes under wellness.
So it's tough. So you have to so the question for folks online is there's a neighbor dispute, for lack of a better term here. All right. You have to whatever process your lease sets forth for addressing those, follow the lease. All right. Well, my lease is silent. Oh boy. This is why we read the lease first, right? Because if we're reading the lease, we're like, hey, if I have a neighbor issue, what do I do? It doesn't say anything in this document. Put things in writing. Email them to your landlord.
I've done it.
Beyond that, it would require me to provide you some kind of legal advice and review documents.
I've applied for Colorado legal. I've been accepted, and I just wondered if, and they're also trying to.
I can't answer these questions.
Okay, gotcha.
All right, because I don't know. All right, I haven't had the time to sit down with you and talk through your issues. I haven't had the time to read through your lease. I haven't had the time to research the landlord, if they own the property, who are the people that are, principals in the corporation that may own the property. And also, is this even a housing issue? Or is this a consumer issue? Okay, and if you're thinking, well, it's the same thing, that's what I don't know, right? And that's why I can't give legal advice tonight. I can answer some clarifying questions, like, what are the rules for rent increase, right? But when we start getting into, well, what do I do?
Oh, okay.
I can't do that, all right? But I don't see anything else online. So, folks in person, did you think of it?
Yes.
Oh, go ahead.
No.
Go ahead. I'll wait.
Okay. Are you still, is Colorado Legal Services still accepting clients with warranty and compatibility questions?
To the extent we can, yeah.
Okay.
To the extent we have the resources, yes. Okay. They are tricky issues, but yes, and also that was a big chunk of what we didn't get to go over tonight, which is the restraining order process and injunctive relief for warranty of habitability. The previous recording has been dropped in the chat. I would strongly recommend going back to watch that, especially if you love the sound of my voice. I don't know why you would, because you can hear me babble on for another couple hours on that process as well. All right. So yes, we are still assisting folks with warranty of habitability issues. Okay. If it's just a simple question, the Justice Center may be a better option, and they'll call a lawyer, because then you're not going through the entire intake process and maybe getting rejected. But if it's a 15-minute question or something like that, I really would recommend the Justice Center. They also have an email lawyer clinic. I'm not saying this because we don't take these. I'm just saying it because that may get you to that may be a quicker route to get you from quick question A to quick answer A. All right.
Okay. I know you said something earlier about all windows are supposed to have screens on them.
By code, yes.
And so that applies to the rental, right? Where you're living, right?
Yeah.
Okay.
Code applies. City code.
All right. What about leaky windows? Because we complained about the windows they're old and we asked them to replace them, and they haven't. And it's we had to. Our utility bills higher because of it. We try to cover the windows best we can to try to, keep our budget in line.
Sure.
And so what do we do about, I know you don't want to tell me what I can do about it, but I'm just saying, yeah. Okay, the waterproof weather protection, roof, exterior walls, windows, right? And that falls under what again? What
warranty of habitability. So this is a condition that materially interferes with your life, health, or safety. If the weather can get in, right?
Yeah.
So I would really it got cut tonight, but go back and watch a prior presentation where I talk more about, and for folks online, the question was about leaky windows. What do we do there? Well, that's a window that's not weatherproofed.
Right.
All right. So if you're looking for what are my next steps after I provide written notice, that's where there's a number of different options, but would really strongly recommend going back to prior presentation, because those where I delved really specifically and more in depth on just the warranty of habitability and just kind of the injunctive relief and temporary restraining orders that can now be sought.
And that's why I'm so pissed off that they went up $200. They want to go up $200 on rent. You know, we haven't even, we asked them to fix it, they ain't fixed nothing, and we just been dealing with it. And I'm figuring, okay, well, gotta give a little, get a little, what we were thinking. Now I'm like, I got gloves on now. I'm not gonna let them get away with it.
Take the gloves off for me and go watch that prior video, and then strap them back on and see what your options are and how you want to proceed. Of course. Thank you for coming out tonight. Yes, ma'am.
Okay, if we want to sit down with someone and ask a lot of questions, who do we get in touch with?
Call a lawyer, or Colorado Legal Services, or CED.
What is that?
Colorado Community Economic Defense Project.
That's part of our organization. There are flyers up there. We also have a law team. Most of our lawyers are located in Denver. But if you do have more questions, and possibly Colorado Legal Services is at capacity, we could possibly connect you with a lawyer. The timing process for non-urgent cases is not in my knowledge right now. I'm not sure what the process is, but I'd definitely be happy to help you connect. Again, everyone's at capacity, but we definitely want to do our best to support you all.
Okay.
You got one word in the chat.
On a one-year lease, if a landlord gives less than 60 days notice of a rent increase, what's the tenant's right in that regard? Can they refuse to sign the lease? I would need to look over these documents. So rent cannot be increased on less than 60 days notice to, or notice to quit cannot be provided to circumvent the laws requiring rent increase. For a termination of tenancy for refusal to sign a lease with reasonable terms, that requires a 90-day notice. So again, without reading the lease in full, it's hard for me to answer that question in a vacuum. And I don't want to give the wrong answer, candidly. So I just can't answer that question further than what the information is regarding rent increases, because you're asking a specific question about a weird. Yeah. So I need to read the prior lease as well. Folks, we've got 6 minutes left. This is bizarre. Normally we're getting chased out.
I got specific questions that you can't answer.
I appreciate that, sir, as much as I would like to.
Yeah.
It's the wrong one, and I do my best not to take blind guesses at something as important as the roof over our heads. Right? But again, I want to thank everybody for taking the time out of their day and their schedule to come out tonight. Really appreciate y'all's attendance and participation. Yes, sir.
Okay. The issue is, okay, my visitors violate, let's say, violation of my lease, because my visitors is there after a certain time, but my lease doesn't say anything about it. The only thing it says is that
something about the rules. Does it have a reference to rules?
No.
Do you have house rules on the building?
Well, they got house rules. They got their house rules, and then there's the lease, and they're like so far apart.
And so this is one of the, you may want to. I would wager a guess that maybe those house rules are a lease addendum. Mm-hmm. So most times, those rules are part of your lease. Mm-hmm. I just don't know without taking a look at it. Right. But so what if you're like, well, what can I do right now?
Which I'm doing. I'm in the
process. Pull the lease, go through it line by line. Painstakingly read everything front to back. Painstakingly read all of the house rules. See what referencing there may be. Mm-hmm. Okay, because more often than not, there is some kind of little detail there, maybe some kind of fine print saying that they're part of the lease agreement.
No, it was, and then these rules was implemented in the middle of my current lease.
And this is also, So I'm gonna bring back another, this is a big reason why I don't know.
Right.
You're in a unique situation,
Mhm.
so I don't know. Okay, because I don't
You don't know
know.
the specifics.
Exactly.
Right.
But another thing to keep in mind is that lease violations are only material lease violations. So a material provision of the lease agreement, whether or not that would be visitors, I don't know. In visiting hours, I'm just not sure, sir. But you have a unique situation, so that's other than me saying I can't do that tonight. You having a unique situation that really is, I'm not touching that question. I'm not giving you,
Right.
I'm not giving you the exact wrong answer just because my ego needs to have an answer.
Right.
So I don't know because you have a unique situation.
No, I just thought I would throw it out there, maybe you knew.
Hey, absolutely, throw it out there. I'm happy to swat it down if I can. Okay. All right, folks. If there are no other questions, then I think we'll call it a night then.
All right.
Thank you.
All right.
Thank you.
Thank you so much.